In an earlier video, we talked about owning a handgun. Now we're going to talk about whether or not we want to conceal carry that handgun. Concealed carry is a different kind of lifestyle. Concealed carry has a mindset that's attached to it that says, I'm going to carry this weapon all the time in the defense of my life or loved ones. Are you ready to do that? Are you ready to pull the trigger when that situation arises? Because once we send a bullet downrange, we cannot retrieve it. We own it. And a life that is taken cannot ever be returned. So when you think about all of these things, you have to decide whether that's right for you. And if it's not, that's okay. But if it is, you've looked at all the parameters and all the important pieces of it prior to making that decision, so you know it's the right one for you. When you carry a firearm, your lifestyle is going to change. It's going to change for a lot of reasons. When you look at a decision to carry concealed, or when you look at a decision to carry, you're going to have to think about the things that you enjoy doing. For instance, say you want to go out to dinner with your wife at a local restaurant that you always go to. That restaurant may serve alcohol. If you're drinking alcohol, obviously you can't carry. But even if you're not drinking alcohol, some states say that if the establishment serves alcohol, you can't dine there if you're armed. You need to know those things. You need to look at all those state requirements and state laws and make sure that you're within the letter of the law and that carrying is the right option for you. Another thing that you need to consider if you're going to conceal carry is, do you travel out of state? A lot of people live at the edge of a border state. A lot of people travel between states for work or regularly for family, whatever it is. You need to decide, do your bordering states have reciprocity? Or in other words, do your bordering states recognize the carry permit from your state to allow you to carry in their state? Now that's not only the state that you're traveling to, that's also the states that you're traveling through. So you need to be very cognizant of those states around you and what their laws are. A lot of adjoining states have reciprocity laws, and you're okay if you travel through those. A lot of them, if they don't, the law can change. In other words, if you're authorized to carry a handgun concealed in your state, but you're traveling to a state that doesn't have reciprocity, you may be forced to stop prior to entering that state, lock that firearm in a box or in an inaccessible location like your trunk. Again, this is all going to be based on whatever that state law is, just giving examples. Travel through that state to another state with reciprocity. Once you enter that state, then you can remove that firearm and carry it again. Sounds complicated, but really what it is knowing those laws and making sure that you adhere to them. Because if not, it's obviously a lot of trouble that you will get in. So, another option may be non-resident permits. So a lot of states, even if they won't recognize reciprocity with your state, will allow you to apply for a non-resident permit. In other words, they will allow you to not only have a permit to carry a concealed firearm in your state, but they will also allow you to apply even as a non-resident in their state. And now you're legal to carry all the way through their state or while in their state. So again, lots of different laws about movement. And when you start thinking about concealed carry, you need to know where you're going to move and where you plan to move through and to, because you need to know the laws in all those states, not just the one you reside in. When you decide to get your concealed weapons permit, you're going to go to your concealed weapons class. One of the things they're going to harp on in that class is prohibited places to carry. You need to listen very closely to that. These are places that are readily identifiable, that are not places that you can carry even with the proper permitting. Those are post offices, federal buildings, schools, even businesses that have the correct signage that prohibits you from being in there with a firearm. That is legal and you cannot go in there with a firearm. So pay great attention to those places, because those are the places you need to stay out of and you need to adjust your lifestyle to, like we talked before. Download that gun, put it in a safe lockbox if you have to enter one of those places to mail a package, do some federal business, whatever it is. But make sure you pay attention in the class and you know those laws, and get yourself a book that quotes your local laws. Knowing those laws will keep you out of trouble. Another big topic of discussion when you go to your concealed weapons class is going to be use of deadly force. Obviously, this is a big deal. If you're going to carry a handgun, you're going to carry it concealed, and if you happen to use it in a defensive situation, you need to know when deadly force is authorized. One of our fellow instructors, Massad Ayoob, covered this very well in one of his videos. Let's see what he has to say.
What exactly is deadly force? Deadly force or lethal force, the terms are interchangeable, means that degree of force that a reasonable, prudent person would expect to cause death or great bodily harm. States have different definitions of great bodily harm, but as a rule of thumb nationwide, it would mean a crippling or devastating injury. Questions asked, what makes the use of deadly force justifiable? Universally in all 50 states, it would be a situation of immediate and otherwise unavoidable danger of death or great bodily harm to you or to someone you had the right to protect.
One of the important aspects of concealed carrying a handgun is our ability to protect personal property. Now, that's really important, and the two most important things to that are castle doctrine and stand your ground laws. Now, those differ from state to state, but you still need to understand what those are so you know if they apply. One of our fellow instructors, Massad Ayoob, covered that in an earlier video as well. So let's go back to him and see what he has to say on those topics.
Now, a moment ago, we mentioned castle doctrine. It's part of our heritage. So much American law comes from the English common law. In the original, the statement was, the peasant's home is his castle. Attacked there, he need not retreat. It also said, the most lowly peasant, his cottage is his castle, and even the king may not enter without a warrant. Now, that element of castle doctrine goes to what we call in this country Fourth Amendment issues, and that's not our topic for today. The element that is on point for what we're talking about is the fact that one is not expected or required to retreat attacked in their home. We need to read the fine print on this. First, a lot of people will say, I tried to look it up on the internet, and poor me, I don't have castle doctrine in my state. I'm afraid that's not true. The castle doctrine holds in all 50 states. In the time of the internet, people's default seems to be, show me the link. You know, point to some piece of black letter law, some statute or code that has a number on it. That's not where you find everything. You'll find the castle doctrine in all 50 states. You've just got to look 3 places to find it. Certainly the black letter law, the statutes and the penal or criminal codes. But you look also at the case law from that state's Supreme Court. And finally, you look at the recommended jury instructions on that topic within that state. Other details you need to watch for in castle doctrine. One state may limit it to home and curtilage. Curtilage being the immediate proximate elements outside the body proper of the house. The front porch, the veranda, the attached garage would be curtilage. A barn attached or very close in some states would be considered curtilage. Some other states extend it all the way to your property, you know, from the house to the street to the farthest boundary. In many states, you'll be justified in assuming castle doctrine when you're attacked in the farmhouse. You may not be so justified if you go down to the fence at the end of the back 40 looking for trouble. Castle doctrine applies to those who have a right to be in the house. In some states, if the man who attacks you was an invited guest, if he has not expressly been ordered to leave, he can argue castle doctrine. We see a lot of domestic issues, domestic violence, where one member of the household attacks the other. As a general rule, since both have castle doctrine, they cancel each other out. However, the law has not been unanimous on that. We had one state, Massachusetts, in the case of Commonwealth of Massachusetts versus Rebecca Schaefer, that decided one way on that. We had another case in Nebraska in which the state Supreme Court held no attack. When the roommate attacked him, he became the aggressor, and basically the other roommate had the right to kill him. So you'll find that's a little bit fungible and not exactly unanimous. Castle doctrine is not simple, and there's very little in the law that is. In line with the Castle doctrine, there's been growing discussion over recent years about the stand your ground issue. Basically, Castle doctrine speaks only to the home. Okay? The individual out on the street in some states is expected to retreat before using deadly force in a violent encounter. The history of that goes back to English law in the middle of the last millennium. It was a time when there was very little organized law enforcement. Two ordinary guys got drunk at the village tavern and decided to go outside and fight, and one killed the other. And the landed gentry, their version was one challenges the other to a duel, and it ends up with one of them dead. And the English decided, you know what, we don't want people getting killed over this stuff anymore. So they brought in a law the concept of homicide se defendendo, which meant that basically if you're attacked on the street, if you've beaten the other man and he's running, if you chase him, you now become the criminal aggressor in a second conflict. If the other man wants to fight you and you could leave, you were expected to leave, to abjure from the conflict. And it was from that that we had the laws that are still present in some states today, requiring you to retreat, if at all possible, before using deadly force against a criminal aggressor. But understand, it doesn't mean that you have to turn your back to the raised knife. It doesn't mean that you have to outrun a bullet. Look it up. There has never been a state in this country that required you to retreat unless that retreat could be accomplished in complete safety to oneself and others. And if you think about it, if you could have retreated in complete safety to yourself and the other innocent people present, you wouldn't have shot him anyway, would you? So it becomes an interesting point of issue. I like the states such as Florida and Texas that over the last decade have passed stand your ground laws that clarified that if an individual was attacked where he had a right to be, he did not need to retreat, period, end. In the practical world, it did not expressly change the rules of engagement. What it did was to make it much easier for you, for your attorney in the aftermath, if you'd had to kill a man in self-defense, to explain why you were not expected to try to crawl out a window or outrun a bullet.
Always a topic of concern when we talk about concealed carry is how do you interact with law enforcement? It's an important topic. While law enforcement is there to help you to protect the public, you are also authorized to carry your firearm if you are a concealed weapons permit holder. However, you need to be very cognizant of your laws in your state. Make sure you educate yourself in your state law. Some states require that you notify that officer that you are carrying. The easiest way to do that is to, when you get your driver's license ready, present your driver's license with your concealed weapons permit and tell that officer that you are a concealed weapons permit holder and you are carrying. At that point, take all instructions from them. Some states tell you you don't have to. It's important that you talk to your local law enforcement, it's important that you talk to your lawyer, and it's important that you know those state laws. Now, if for some reason you happen to be in an incident where a shooting has occurred that you're involved in, now you're in a different set of rules and a different set of interactions. Massad Ayoob actually had this covered in one of his topics, so we're going to go back to him again and see what he has to say.
You hear a lot of people tell you that after a self-defense shooting, when the police get there, you should say nothing. I have to respectfully disagree with that. Over the decades, I've seen that get innocent people into a whole lot more trouble than it got them out of. What you've got to understand is that advice comes from defense lawyers. Now, they don't call them criminal lawyers for nothing. and I don't mean it in that sense. They defend people accused of crimes. My experience on both sides of the defense, working defense teams as an expert witness and as a prosecutor for the other side, is I would guess pretty close to 97% of the people who are charged are guilty of what they were charged with, or at least of a lesser included offense. That's certainly the collective experience of defense bar. I hang around with a lot of criminal defense lawyers. I spent 2 years as co-vice chair of the Forensic Evidence Committee for a National Association of Criminal Defense Lawyers. I've talked to attorneys who, after a 30-year career, could not remember defending a truly innocent person. I talked to one 2 years ago now. He was defending a young woman who had shot and killed her estranged husband in self-defense. I spoke for her as an expert witness. We won an acquittal in record time. The jury was barely out. And that evening, he and his wife and my girlfriend and I were having dinner to celebrate. And I asked the attorney, who'd been doing this for like 35 years, how many of them are like this, John? You know, how many give you this thrill of freeing the wrongly accused? He says, oh, it happens. I'd say at least it's 1 out of 100. Now, the converse of 1 out of 100 innocent is 99 out of 100 guilty. And if most of your clients are guilty as charged, what could they possibly say to the police that would help them? So, of course, the advice of the criminal defense bar is say nothing. When you, the innocent person who fired in self-defense, follow the advice of essentially a guy whose whole experience is defending criminals, you may be going down the wrong path. Okay, Ayoob's law number 30, if you will. If you take a guilty man's lawyer's advice and you act as a guilty man would act, you're going to end up with a guilty man's verdict. So I've come to believe over the years that certain things really do need to be established by the shooter, who is now a potential defendant, right there at the scene. For decades now, I've recommended a 5-point checklist of things that need to be established at the scene. First, briefly explain the active dynamic. And the active dynamic is not, I shot him. The active dynamic is why you shot him. This man attacked me. This man attacked my wife, whatever it was that led to your use of force in defense. Second, explain to the officers that you are prepared to sign the complaint. When you say, I will sign the complaint, you're speaking their language, and you're confirming that you're the good guy, and the guy laying on the ground doing a very convincing imitation of a victim is, in fact, the perpetrator. Third, point out the evidence. Okay, evidence is ephemeral. It's perishable. It gets moved. It gets lost. If the cops don't know what to look for, they won't find it in time, and it will disappear, and the evidence that would have shown your innocence is gone with it. Okay, I've seen spent shell casings picked up on tire treads and shoe treads. Okay, the knife that the offender threw as he fell went down the sewer grate, and the storm clouds are gathering, and pretty soon there's going to be a rushing river of water going through there. That evidence will disappear. That knife with his fingerprints and his DNA on it that will show, yeah, he was coming at you with a blade when you shot him, is going to be gone because you did not alert the police to where it was and where to look for it. Fourth, point out the witnesses. Witnesses are notorious for not wanting to get involved. If you don't point out who saw it, particularly if the person who saw it is a transient just passing through, the cops will never be able to find them later. And the testimony that would have proven your innocence is going to disappear with them. It would be after that, at that point, that I would say, officer, you'll have my full cooperation on any other questions after I've spoken with counsel.
So in conclusion, now we have to decide, is carrying a concealed firearm the right thing for you? If it is, find out what your local laws are and your regulations and requirements. Get to that concealed weapons permit class, learn everything you can, get your concealed weapons permit, and now we got to do the next step. Now we have to start training. Now we have to learn, how do we carry concealed? We have another segment on that. Please feel free to watch it. It's full of information. But most importantly, use all of these tools that we talked about to make sure that you know what you're getting into when you decide to do your right to have a concealed weapons permit. And be safe.